Disclosure obligations to the non-client. A broker has no fiduciary duties in the absence of a broker-client relationship. See, e.g., Norville v. Plant, 25 Arizauer, App. 606, 545, P2D 454, App. 1976. Thus, the disclosure obligations owed to the non-client are narrower than the disclosure obligations owed to the client. For example, in Buffington v. Haas, 124 Arizor 36, 6001 P2D 1320, 1979. The court found that a broker who did not represent the seller was not liable for failing to disclose that under the contract, the seller did not retain a security interest in her property. The Buffington court stated, "There was not an agency relationship between the real estate salesman and seller, therefore, the salesman had no obligation to inform the seller." The duty to deal fairly. Although a broker has no fiduciary duties to the non-client, a broker still has a duty to deal fairly with a non-client. Arizona courts have consistently held a broker accountable where the broker fails to deal fairly with a non-client. Commissioner's Rule, AAC, R428-1101, A, states, "A licensee owes a fiduciary duty to the client and shall protect and promote the client's interests. The licensee shall also deal fairly with all other parties to a transaction." This rule acknowledges the agent's fiduciary duty to its principal, while recognizing the agent's non-fiduciary duty to other parties to the transaction. This duty to deal fairly with the non-client is compatible with the broker's fiduciary duties to the client. Commissioner's Rule, AAC, R428-1101, B, is explicit in regards to the disclosure obligations owed to non-clients. A licensee participating in a real estate transaction shall disclose in writing to all other parties any information which the licensee possesses that materially and adversely affects the consideration to be paid by any party to the transaction, including 1. Any information that the seller or lessor is or may be unable to perform. 2. Any information that the buyer or lessee is or may be unable to perform. 3. Any material defect existing in the property being transferred. And 4. The possible existence of a lien or encumbrance on the property being transferred. A Court of Appeals case, Aranki v. RKP Investments, Incur, 1R94 Arizar, 2106, 979, P2D 534, Appar 1999, addressed the duty a broker owed to a non-client and stated that, as agents of sellers, the listing agent owed a duty to the buyers different from the full and frank disclosure they owed to their principals, the sellers. Their duty was to deal fairly with all other parties to a transaction. In explaining the scope of the duty to deal fairly, the Aranki court stated, "The duty of fair dealing does not include investigations to discover defects in the seller's property. The law does not, for example, require escrow agents, who act as fiduciaries for buyers and sellers alike, to investigate on behalf of their principals. Such agents are merely bound to disclose circumstances that a reasonable agent would perceive as evidence of fraud." See Burkons v. Ticor Title Insurance Co., 168, Arizar 345, 353, 8113, P2D, 710, 7018, 1991, AAC, R428-1101, B3. The Aranki court found that the listing broker in that case was not liable to the buyers for passing along information obtained from the seller without proof that the listing broker knew or should have known that the information might be false. A broker's disclosure obligations to the non-client were also discussed in Lombardo v. Albu, 199 Arizumber 97, 14 P3D 288, 2000. In discussing the duty of a buyer's broker to the sellers, the Supreme Court quoted with approval a section of the Restatement of Second of Agency, which states, "Although the making of a contract by the agent does not constitute a representation by him that his principal is known by him to be solvent or honorable, if the agent knows that the principal does not intend to perform the contract because of hopeless insolvency or other reason, the making of the contract for him under such conditions subjects the agent to liability." Citations omitted. Likewise, if the agent fails to reveal circumstances that make it impossible for the principal to perform, the other party has the remedies given for misrepresentation. Further, the Lombardo court confirmed that when the broker's client has a duty to disclose to the other party, the broker has the same duty to disclose. Therefore, it is important to be aware of the seller's disclosure obligations to the buyer and the buyer's disclosure obligations to the seller. In a nutshell, disclosure to the non-client. As discussed above, at common law, a broker is obligated to disclose to a non-client any information that the client, whether seller or buyer, is or may be unable to perform. Any known material defect existing in the property being transferred. Additionally, brokers should be aware of the statutory and administrative disclosure requirements such as Truth in Lending Act disclosures in advertising pursuant to Regulation Z, if the broker is acting as a principal in the transaction directly or indirectly. AAC R428-11001E, if the broker is accepting compensation or representing both parties. AAC R428-101F. If the broker is advertising the broker's own property for sale, the broker's status as a broker. AAC R428-502B. The terms, costs, conditions, restrictions, and expiration date in any promotional activities. AAC R428-503B. Remember, the failure to disclose required information may result in civil or administrative liability, so be diligent about disclosure and evidence all your disclosures in writing.